kind of advice do you have to homeowners?
Practicing that preparedness, starting the conversation now is always going to be a benefit to any association out there.
And welcome to the Recovery Report Live, GlobalPro's deep dive into relevant business and insurance topics, providing actionable takeaways and valuable insights. We aim to update, educate, and inform you weekly. I'm Dan Odess, president of GlobalPro, where we manage risk to recovery. For more than a decade, we have represented thousands of businesses and community associations in the placement of insurance and the recovery from over $1 billion in damages. We are your source for insurance news you can use. In last week's episode of the Recovery Report Live, we hit on a number of condominium insurance topics. Today, we want to continue that discussion with our very own Josh Bochner. Very excited about today's broadcast. Before we get there, I want to highlight some recent updates for our business owner clients. A reoccurring theme with all of the courts in our position from day one, literally day one, we've been saying this. If you've been tuning in, you've consistently heard us talk about this. Handle your claims first. When handling pandemic-related losses, each claim must be adjusted and handled on its own individual merits. Numerous courts have denied insurance company motions to dismiss lawsuits by focusing on specific facts, policy language, business operations, and local state regulations, et cetera, et cetera. I can go on and you probably go to sleep, but the reality of it is that each case must be determined based on its own merits. And we've been saying that from day one. And what's important about that is we've been telling our clients, adjust your losses first. Establish your claims. Then, if the insurance company wrongfully denies your claim, then sue. Cases in New Jersey, like Blue Springs, Florida, like your oncology specialists of Florida, and various other states recently were heard and fought based on a set of facts and circumstances that are specific to each claim. The failing to acknowledge the nuances of insurance early on was a mistake made by a number of plaintiff attorneys hoping to get to the courts first. And I think cases like Blue Springs and your oncology, I think what you're seeing there is that they've actually gone back and realized that each of these cases is nuanced, right? You have issues inside of policies, you have issues with regards to the law, the ways in which things are presented, your local state authorities and their orders that were entered. There's so many different nuances to it. So again, look real closely to that, look really closely at that stuff, and stop with this foot race to the courthouse. Similarly, insurance companies that refuse to conduct physical investigations and quickly deny claims deprive policyholders of their rights to a fair process. Frequently, we saw insurance companies absolutely just refuse to come out to properties, claiming that there was a risk, ironically, or that it was not necessary, despite the fact that their own claims manual, I'm sure, say that they need to conduct actual inspections of the property. And a lot of times, even if they did come out to the property, they refused to actually enter the property, despite then arguing on its face that there was nothing in the property or no damage. So if there wasn't physically anything in the property, then why couldn't they actually conduct those physical inspections? Similar to the assumptions made by many regarding coverage for the pandemic, community associations frequently struggle with construction-related losses. We've discussed some of these issues in prior broadcasts, but I want to get into these details today with our very own Josh Bochner. Good morning and welcome to the Recovery Report, Josh.
Thanks for having me, Dan.
So we just talked about some technical, some complicated things regarding some business owner losses and some things we've seen in the courts, some confusion over the nuances of certain policies and conditions and how jurisdictionally things may be different. And while we're not going to be giving legal advice today, and that's definitely our disclaimer here, we just want to simply go over the facts in these different cases so people are just aware of the opinions that are out there. Josh, being a native of Florida and a member of the Florida Bar, helps our clients every day, working closely with them to help them dealing with their losses, helping them with their recoveries, going through the process from start to finish, ensuring that they have a fair recovery and that they have all the answers to many of their questions as it relates to placing the insurance, to recovering from the loss. So I'm very excited to have you here with us today. Josh, why don't let's start off by talking about a rather, where it all began, let's just say that, here in Florida. You've picked out a few cases, just to give it a little precursor to this, few cases that we think in chronological order create a basis and some relevance for our community associations that may be dealing with these construction-related losses. And the first one we have is Wallach versus Rosenberg. Yeah. What's the issue there?
So we thanks again for having me, Dan. We selected a few cases that we think are going to be tailored toward these community associations and clients of ours that have these commercial claims. And the focus is trying to look at when you have multiple perils or multiple causes of loss that combine to cause a loss, issues that may arise that the insurance company brings up or tries to deny coverage with. So we're going to start with a 1988 Third District Court of Appeal case. Miami, Broward, we sit in the Third DCA, as you know. So the first case is Wallach versus Rosenberg. And it's actually one of the first, if not the first cases in Florida to apply what's known as the concurrent cause doctrine. And I'll get into that a little later, but let's start with some of the facts of that case. What happened here is there were two property owners, the Rosenbergs and the Wallachs, and they shared a seawall, basically circled an entire island where there were multiple homes. And there was a very stormy day that came through, and basically the seawall on one of the properties fell. The Wallach seawall fell, causing a domino-like effect and crumbling of the Rosenberg seawall. That's the basics of the facts. The insurance company here was trying to argue a theory that was eventually struck down, the efficient proximate cause doctrine. And what the insurance company wanted to say was, whatever the efficient proximate cause of the loss was, that's the cause. And if that cause is excluded under the policy, there's no coverage. The court rejected that theory and disagreed. And they said that where multiple causes combine to create a loss, such as weather conditions and human negligence, which is their potential lack of maintenance of the seawall, and only one of those is excluded, you can find coverage for the claim. So the court here applied for the first time ever what is known as the concurrent cause doctrine. And the holding in this case, which is actually still used today, and we use it in some of our claims, is where you have a weather peril, which is arguably excluded under the policy, and it combines with a covered cause of loss, such as negligence or human negligence to cause a loss, it would be logical and reasonable to find the loss covered by an all-risk policy. So it's a great case. It stands for a couple propositions. The first, that the concurrent cause doctrine is what's applied in Florida, and we'll discuss how that was affirmed later in another case, and also how you can have multiple perils or causes of loss that combine, even if one's excluded, and still have coverage under the policy.
And interesting you say that. And fast forward, so that's 1988, right?
Correct.
So
that was decided in 1988.
So we affirm the concurrent causation doctrine in its application here, an efficient cause and an explanation of those, basically distinguish between the two. Fast forward to 2012, a case I'm actually very familiar with, a case I briefed, was contacted by a construction professional, a client that was developing a property in the Gainesville area. I briefed the matter, was actually reviewing documents submitted to them by an insurance consultant they had previously hired, found issue with the way in which the case was being presented, briefed it, they got counsel involved, and then we're very successful in this case. And this case is Bartram versus Landmark, or Bartram LLC versus Landmark America. So why don't you take us through the little bit of the nuances of that matter?
Sure. So the Bartram case, as you know, you're intimately involved with it and aware. This is actually a federal case as opposed to Wallach and Rosenberg, which was a state of Florida case. And another very interesting legal concept came out of this case. So again, we'll start with the basic facts, which is a apartment building was constructed and there were allegations of faulty workmanship. Again, arguably an excluded cause of loss under the insurance policy. And the insured was trying to argue that there was still coverage for the claim based on an exception to the exclusion. So taking a step back, in insurance law, when an insured is presenting the claim, all they have to do, at least in Florida, is present a claim to the insurer that you had a loss or damage occurred during the policy period. The burden would then shift to the insurer, the insurance company, to prove that an exception or a limitation, an exclusion or limitation applies that would bar coverage. If they're able to do so, the burden then would shift back to the insured, the person claiming loss or damage and coverage under the policy, to say that there's an exception to that exclusion. So here, the insurance company was saying that the faulty workmanship exclusion would apply. However, in the policy, there was a specific exception to the faulty workmanship exclusion. We refer to it as the ensuing loss exception, right? And again, this is where your little disclaimer at the beginning would come out. Every claim needs to be evaluated on its own merits, its own facts, based on the policy language. Some of the policies will have this exception to the exclusion and some won't. But here we had it. And the way that the court reasoned was that because there was ensuing loss and damage that resulted from the faulty workmanship, and they weren't claiming the faulty workmanship itself was the loss or damage, the court found coverage, or said that the exception to the exclusion could be applied here. So even though there was poor workmanship, and that was arguably excluded in the policy, because the poor workmanship resulted in water intrusion and water damage into the property and caused significant damage to the property, which was not the poor workmanship in and of itself, the court said that there could be coverage there based on the ensuing loss exception. So again, it's a very interesting case, and it provides a very interesting legal theory that if you have that exception in your policy and the insurance company is trying to exclude it based on a poor workmanship exclusion, you may still have coverage if you can identify ensuing and resulting loss from that poor workmanship. Which
we see a lot here in Florida, especially with our weather and the conditions that the extreme conditions we see with regards to the hurricanes and the rains and the thunderstorms and whatnot. We see these claims all the time. Unfortunately, a lot of times we're the recipient of these claims after counsel has reviewed them on behalf of the association, and they've engaged in some very costly legal writing back and forth with various different parties when there is this very easy opportunity at a recovery. But it's not easy to navigate the policy process. It should be easy that in the fact that there actually is coverage afforded to you. You just need to know how to actually make that claim and know to what extent you can make a claim for. And this precedent was reaffirmed in a later case in 2016. Is that correct, Josh? SIBO versus American Home Assurance?
So the SIBO case actually reaffirmed the Wallach v. Rosenberg case that was decided in 1988 in the application of the concurrent cause doctrine. So in SIBO, there were basically two different ones. The one that we're going to discuss is the one that affirmed the concurrent cause doctrine as the applicable theory to apply. But originally what had happened is the court denied coverage for the claim in more or less applying the efficient proximate cause doctrine. So SIBO is actually a Florida Supreme Court case. And because there was a dispute between the court, the initial SIBO decision, and Wallach, which had applied the concurrent cause doctrine, the Supreme Court took the case and heard it. And what the Supreme Court said was where there are multiple perils that combine to cause a loss, you need to determine what the appropriate theory of recovery is. Is it the concurrent cause doctrine or the efficient proximate cause doctrine? And the court said that the more appropriate theory to apply, where one of the insured risks is a concurrent cause of the loss, would be the concurrent cause doctrine. So the court affirmed the application of the concurrent cause doctrine as provided in Wallach, and the court here rejected the efficient proximate cause doctrine. And the court said in SIBO, and again, the facts basically are that there were significant design and construction defects in a home. Again, that would arguably be excluded under the policy. But Hurricane Wilma came through and caused significant damage to the home. And you could not ascertain were all of the damages caused by the poor workmanship and the significant construction and design defects or the hurricane. And one cause could not be determined as the efficient proximate cause. Effectively, both combined together to cause the loss and the damages. Because of that, where one of the causes of loss would have been excluded, the poor workmanship, and the other was obviously covered, damages that resulted from a hurricane, and you could not tell which was which or what caused the loss, the court felt the more appropriate theory was to apply the concurrent cause doctrine and state that because one of the causes of loss was covered, there's coverage for the loss and the damage.
So all very important facts. While it should be easy to determine your coverage, as most of our audience will appreciate, it's certainly a complex process by which you need to go in order to distinguish between those damages you can claim for and those you cannot. But the reality of it is that in Florida specifically, we do have these precedents which allow our clients, our community associations frequently to recover for these damages. And it's another way, and the reason why we've gone through this exercise today is to highlight another way in which to deal with construction-related damages. And we are frequently doing that, and Josh and the rest of our claims management team are working closely with our clientele to ensure that they are getting the best recovery that they can for their damages. These are very expensive, typically very expensive repairs, whether it's to the defect itself or the ensuing damages caused by that, caused by the covered cause of loss, the ensuing loss. It's something that obviously takes a lot of sophistication, a lot of expertise, and we certainly have those people on our team here, as Josh has so eloquently demonstrated. Extremely excited to have you on today, Josh, and to provide all this information to our clients. You have any closing words for our audience that has tuned in today?
Yeah, the only thing I would mention is, these claims examiners, when they're going through the process of evaluating your claim, they may not be as familiar with the Florida case law as a lawyer or an insurance expert like we have here at GlobalPro. So, you may get a letter and doing the claim yourself where they're applying an exclusion completely wrong, or they feel that an exclusion or limitation is applicable, but they don't understand the consequence of this case law and how it applies, such as with the ensuing loss exception to an excluded loss. So it's important to have an insurance coverage expert or someone who is well-versed in this, managing the claim and communicating with the carrier and putting these points and these legal concepts in writing to them so that if it does end up in a litigation context, everything's been laid out on the table for the insurance company and you have a much stronger case to make that there either is bad faith or they did clearly breach the contract based on the state of the law.
Yeah, and frequently we find, and we talk about it weekly, these examiners don't even have copies of the policies in front of them when they're making coverage determinations, and they make assumptions because they've been given some template form denial letter or were in some class a week before. God knows where they get the information from, but they make assumptions that certain things are not covered or excluded, and they group things. And I think what this gets down to is that you need to look at these things in detail. You need to look at them differently. And I think that there's opportunity out there that unfortunately gets grouped into a lot of very costly litigation, whereas there's a recovery right there for an association to take advantage of in order to start that rebuilding process. Because I think a lot of times insurance companies miss the idea that these are people's homes. And the longer that this takes, the more of an issue that it is. And had it been their own home, they certainly wouldn't stand for the delays that we see in a lot of these cases. That is either inadvertently caused by the desire to litigate or the unnecessary denial or delay in these claims. So really incredible information. Something we've been doing here at GlobalPro for quite some time. As I mentioned, we were very much an integral part in an earlier case, and we've been doing this from day one as a licensed general contractor, working with professionals like Josh from day one. We want to make sure that our clients' interests are consistently and constantly protected, and I think that's what we're doing here and demonstrating for our audience that there's another way to look at these things, And if you have any questions or concerns, you can always reach out to our team. We're available 24/7. Again, Josh, thanks for joining me today. Thank you for all of our attendees that tuned in this week. Go online. I totally encourage you to check us out at getglobalpro.com. Check out our website, click the resource section to read and download important information you need to be prepared. There's still some areas of interest out there, so we're still not out of storm season. So stay vigilant in your preparation. Be sure to check out our YouTube channel to watch today's broadcast and all of our prior broadcasts. Like us, follow us, and engage us on all of our social media platforms. We love to connect with our clients and community. Like I said, 24/7. Call us anytime or shoot us an email. And remember, we're still doing our campaign to support the local restaurant communities. Love in a Bag. Check it out. GetGlobalPro.com/Love in a Bag. Reach out to us. Contact the local restaurants. Get some love in the bag. It's an incredible campaign. Super excited about it, and we're getting a lot of attention for it. And we hope all of our restaurant community continues to recover from this terrible pandemic. Remember to tune in next week. We have a very special guest joining us, Michelle Gallo. Michelle and I will be discussing work-life balance for moms that are business owners, a unique term called mompreneurship. Certainly an important topic, as most people are still working from home and using technology in many, many different ways to escape the office. Again, thank you, Josh, and all of our attendees for tuning in this week on the Recovery Report Live.